All right, hello CUNA. We are going to be reviewing the Board of Ada County Commissioners public hearing June 12th, 2024. And let's check the audio.
Oh, okay, well, we got that.
All right. I already checked the agenda, and really the only one that seemed to hit our area was the river, is this one right off of 7000 South Pear Blossom, and it's just a pretty small project. It's basically crossroads of Lake Hazel Road and Meridian Road. It's pretty small. So north of CUNA, but interestingly, I'm working with Kevin as well right now. So with Kevin Farrell, so I didn't know he did these works. So anyway, let me see if I can pull this one up specifically, so we can jump right to it. I had jumped through this, and it's interesting. You have one of the candidates that ran. I don't know what property she was referring to.
Needed to be able to get to their property. They were actually
Probably my standard.
So this was a variance. I'm not sure if she was she's the property
Okay.
owner.
Discussion. Is the motion clear? I think I know.
Sharon.
All right. We have a second to the motion.
Sorry,
I'll second. Okay. Parties and nothing we're voting on tonight would preclude when you're asking the government to make a decision. Somebody's probably going to win issues, and if not, I suppose this.
Yeah, Sharon Ullman.
We're going to ask our staff to present the staff report. Go ahead. All right. Let's have take up, and I'll open the public hearing on application 2024-006-19A. Sharon.
Okay, let me pull this up. 202419. And see which one that was. Oh, there it is. Okay. So she appealed the director's approval of 2 zoning certificates and the associated building permits, which is pretty interesting. Let me pull this up, see if it affects really CUNA. If not, I'm just gonna review it at the end. Yeah, no, it doesn't. It doesn't affect CUNA at all. But I just find those cases interesting and would like to hear their deliberation on that. But that's I'll do that at the end. So we'll get through this one, which could be relatively related to CUNA, but otherwise nothing within the city districts or within the city boundaries. Starry. This was right before number 3. Sometimes it's hard to pull up these numbers. So let's see if maybe I can search by the number 193.
Preservation District to make the property legal non-conforming and make.
And sometimes they reschedule these. So I'm trying to see if I can pull it up. Let's see if Kevin spoke. There we go.
I can't.
Can't.
Exhibit number 51, and I will stand for any questions.
Any questions?
Comments. Fee per lot project honors presentation will be known as exhibit number 51, and I will stand for any questions.
Any questions? Okay. All right. Thank you. Is the applicant here? Kevin?
I can't.
Can't.
With River Ridge Engineering.
Okay.
We're at 2447 South Vista Avenue, Boise, Idaho. Thank you, Commissioners, for hearing our application, and thanks, Amelia, for all your hard work. Tim and his sons built the house that's on the property now. They're just looking to subdivide it into another 2 lots and maybe build a couple more homes on there for the family and everybody there. Pretty simple subdivision. I think that we have crossed all of our T's on this one, and I'm here to take any questions that you have.
All right. Any questions? All right. No questions? Thank you. Thank you. All right. Amelia, do we have any additional documents need to be added to the record?
We do not.
Okay, thank you. I'll close public hearing on application 2024-00193-SZCDAPR, River Ridge Engineering. What's the pleasure of the board?
Mr. Chairman, I move to approve application 2024-00193-ZC-DA-S-PR, Starry Night subdivision, based on revising findings of fact and conclusions of law contained in the staff report and testimony we heard tonight.
I'll second that. Okay, you've heard the motion. All in favor, say aye. Aye. Motion carries. Thank you.
Okay, wow, that is has to be that was very fast. No one came to talk except the owner. All right, good for them. Yeah, no, I didn't work with, I think he said it was Kent. Let's see, Rodney Evans. I've worked with Rodney, so I'm kind of curious. Let's see if he came and spoke.
2024-00636-V-CU-MSP, Rodney Evans and Partners, LLC. And we'll ask our staff, Michelle. Is it Michelle?
Michaela.
Michaela. Okay, Michaela Owens.
The area where the site is located, it is on the south side and is located in processed by Ada County. Plan with 36.
So, I mean, in terms of the video, it's pretty much done now. I'm just perusing it live myself or whatever interests me.
Vehicle and trailer storage areas that's currently on the site will remain on the site as a dwelling unit that's required for this use. It is allowed conditionally in the RUT zone and would be allowed detrimental to the public health, safety, detrimental to the public health. The following are key comments that were received. Aligned with health is requiring that an expected wheel restraints be provided to prevent vehicles from this application. So inspection will be required after construction.
Yeah, that'd be a condition.
So landscaping plans and
People going in and out.
Any other questions?
What are the wheel restraints that you're referring to?
Mr. Chair, no ADA issues per se, just indicating that Leslie Prendeville with Rodney Evans and Partners. 1450
Okay,
West-
no, it's not who I worked with, so. All right, now let's go to Sharon Ullman's project. Let's pull up the report. She was running against Tom Daly. So it's always, you know, you're always, you know, you don't want to be going scorched earth on somebody and then you have to get their approval. Let me see.
I'll open the public hearing on application 2024-006-19A, Sharon Ullman. We're going to ask our staff to present the staff report. Go ahead.
All right, thank you, Chairman Commissioners. 1 moment. Sorry, PowerPoint's been giving me some challenges today, so I apologize. All right. So thank you, Chairman Commissioners. The application before you is an appeal of 2 zoning certificates associated with the issuance of 2 building permits for accessory structures on the subject property. The applicant is Sharon Ullman. The subject property is located near the city of Boise, directly adjacent to Boise city limits, and at the end of Zaffery Ridge Street. Surrounding uses include single-family homes to the north and west, and undeveloped rangeland to the south and east. The site is a 2.77-acre property in the R8 district. It contains an existing single-family home as well as accessory structures and a riding arena. The current property owner takes access from Columbia Road to the north via an easement that crosses HOA land along the eastern boundary of Painted Ridge subdivision. And so I'll highlight that here. So here is the driveway, which will be discussed a lot during this presentation and tonight. And then here is the Zaffery Ridge Street that terminates at the property on its western edge. So the applicant has requested to build 2 accessory structures, one at 1,499 square feet, that is the proposed barn here, and another at 600 square feet, which it looks like my little red circle disappeared, but it's the proposed run-in shelter down here. Regarding the appeal, the appellant has made 5 points as summarized by staff and detailed in the staff report. The first involves noncompliance with Ada County Code, Section 8-48-3, access to and frontage on a roadway. As noted in the staff report, the appellant believes that based on this code section, making use of that easement to Columbia Road to the north should not be allowed. That's a very broad generalization of what they've said. They'll give you a lot more detail during their testimony. There's a long history here, and that is the second point. The easement has existed prior to the platting of Painted Ridge subdivision and has been used by the property owners of the subject property. There's statements made by the appellant that based on the development agreement associated with the Painted Ridge subdivision as well as other documents, the use of that property should go away. There was a letter from our director included in the staff report and exhibits tonight that detail kind of what's going on with that easement and what Ada County's role is. In general, it is not Ada County's role to determine who makes use of an easement or not. It is only Ada County's role to ensure that any property has access and frontage when it is developed. The Zaffery Ridge Street does qualify the property under that section, but again, it's not Ada County's position to tell a person which access they use. If they happen to have an easement, they're allowed to use that easement. And if there were any differences in opinion there, that would be between the HOA property owner that controls the land associated with the easement and the property owner themselves. Other points made by the appellant is there were requested entitlements. The requested entitlements for the property over the years should have made this easement go away. I think this falls into the same bucket as the last explanation. But again, it's not our role to remove someone's easement if we're not the grantor or grantee. We are outside of the situation as it relates to that easement. There's claims that the use of the easement has been for non-residential purposes. The only use approved and existing on site right now is a residential use. So any delivery truck or maintenance person or landscaper that comes to the site is to serve the residents on the property. And so it's staff's position that no residential uses of the property are occurring, and therefore no use of that easement is for non-residential uses. I do know that previous ownership had some other things occurring on the site, and code enforcement had been out there multiple times to talk to them about trailers being stored on site, potentially riding classes for horses. Again, all of that was a prior owner, and none of that is occurring with this property. If those things were to occur, they would need a planning approval. And again, their argument about that easement could carry more water, but not again with Ada County. It would be the HOA to determine whether or not that easement is being used appropriately in conjunction with the property owner. And then finally, There's claims of trespassing on adjacent properties east of Painted Ridge subdivision. Ada County has received no complaints from those property owners about trespass. And again, if that were to occur, it's outside of our responsibility to resolve that. That's between the property owners and the person driving on the property if they are indeed trespassing. So for those reasons, staff does not support these points for the appeal. In terms of comments we received from different agencies, our building official had no objections. They've issued a permit for those accessory structures, as well as zoning certificates issued by the planning division in our department. City of Boise Public Works commented on this one, oddly enough, and they have no issues with the accessory structures. And I mentioned before, our director wrote a letter to the appellant, Ms. Ullman, regarding this issue because it had been on our radar for a while. We had received some complaints and concerns, and ultimately it was determined that, again, this
All right, just to be clear, Sharon Ullman lives basically at this house, so she has a direct interest in this.
is not an issue for us to resolve. This is between the HOA and that property owner. And if the HOA doesn't want them making use of that easement, then they would have to go to the trouble of removing that easement. But again, it's not our position to regulate that easement. And in fact, with the Painted Ridge subdivision development back in the day, a previous commission identified that we're not here to resolve this matter between you two. That's up to all of the people concerned with this, and particularly the HOA who owns the property, again, associated with the easement area. In terms of public comments, we received 8 in total. 1 comment from a resident of the subdivision that supported the appeal and wanted that easement eliminated and did call into question its use. They cited reasons of safety for the neighborhood and again, kind of sided with the appellant in regards to why the easement should go away. There were also 7 comments received in support of the current use of that easement area and the current property owner. Those included comments from the Painted Ridge subdivision HOA, the former president of the Painted Ridge subdivision HOA, multiple residents of Painted Ridge, the attorney of the subject property owner, and the owner of the property themselves, and all arguing to allow the continued use of that easement by the owner. In terms of project findings, staff finds it to be in compliance with our appeal section, which basically says that this was an affected party and was filed in a timely manner, and that the project also complies, the zoning certificates in particular comply with our zoning code for zoning certificates and how those can be approved. So in conclusion, staff is recommending, that's incorrect, a denial of the appeal, 2024-00619A, and I'll stand for any questions.
Any questions? Go ahead.
Yes, just as a clarification. So to make sure I understand this, one, Ada County doesn't have any jurisdiction over the easement or the granting or the restrictions on these or revoking of the easement. And it would be the subdivision and the property owner that would have to make that decision.
Yeah, Chairman, Commissioners, that's correct.
And the easement's granted by whom?
It was granted by the HOA, basically the Painted Ridge subdivision HOA is the grantor of that easement to this property owner in terms of being allowed to cross that common lot on the eastern side of the property.
And you said a previous board, Ada County Commissioner Board, has addressed this issue in the past?
Yeah, Chairman, Commissioners, with the original entitlement of Painted Ridge subdivision, that easement driveway came up. It was something discussed quite a bit, and ultimately that commission determined that it has no cards to play in terms of the easement itself. That is between the subject property owner and the land that the easement crosses over, which happens to be HOA-controlled land.
Thank you.
Any other questions? Go ahead.
With regards to was it eight people who commented in opposition to the appeal? Are they all connected to the property in question, or did you say that the HOA itself was one of the submissions?
Yeah, so everyone who commented is from the area except for the attorney of the property owner. There was one resident who lives in Painted Ridge who does not want that driveway to be used. That's in addition to the appellant. And then there are multiple residents who live in the subdivision that want the continued use of that driveway and that easement, as well as the Painted Ridge HOA and the former president of the Painted Ridge HOA, and obviously the property owners themselves.
So does that mean the HOA took a vote to send this letter? What kind of documentation did you get?
It was an email from the Painted Ridge subdivision HOA, and I personally don't know if they voted on that I would assume they did as an HOA, but again, we don't get involved with HOA proceedings to confirm how they voted, but that was a statement from the Painted Ridge subdivision HOA regarding this matter.
All right, thank you.
Okay, any other questions of our staff before we proceed? Okay, thank you. Is the applicant here? Yes, okay. Welcome to the meeting.
Thank you, Mr. Chairman, members of the board. My name is Sharon Ullman. I live at 5991 East Zaffer Ridge Street I do not. I live at 5991 East Black Gold Street. Zaffer Ridge is the subject of this issue. First of all, I want to clarify a couple of things. Do you have the aerial photo of the area in 2013? It's one of the exhibits.
I can pull that up. I'd have to go into the staff report, but
Okay, if you could pull that up, I'd appreciate it. In 2013, there was only one house on 40 acres, and it was the house that's now known to be at 5900 East Zaffer Ridge Street. It made perfect sense to have an access easement. You absolutely had to do that while this development project was taking place because that owner needed to be able to get to their property. There were actually a couple of easements. Once Amber Ridge Avenue went in on the far west side of the subdivision, the other one terminated. Why there wasn't a provision specifically written into this one to terminate, I suspect it's because that back portion of the subdivision was not being contemplated at that time.
I'm working through your details.
Okay.
I'll try to find it here in just a second. Are we getting close?
You're getting close.
Okay. Yeah, I'm sorry. Let's see here.
So that's where
In any event,
Sharon
it's a
lives.
big piece of farmland. There was one house on it, quite a distance from
Let's
Columbia
see.
Road. The access easement was absolutely mandatory. The developer granted that easement to the owners of that property. They later teamed up and developed more of that 10 acres. That's what left the remaining 2.77 acres that we're talking about today.
I think I may have found it here. Is this the property?
That looks like the one. So as you can see, there weren't any roads. An access easement was absolutely necessary. Gentlemen, John Adams said we have a government of laws, not of men. If that's true, shouldn't those laws be followed and enforced? Multiple times now, owners of the property containing the piece now known as 5900 East Zaffer Ridge Street have signed on to conditions of approval and a development agreement that say they agree to comply with the Ada County Zoning Ordinance, Title 8, Chapter 4, Article A. The conditions of approval from 2013 for the Painted Ridge subdivision, the initial part, specify that the property must be managed and maintained, consistent with the standard regulations in Title 8, Chapter 4, Article A of the Ada County Code. That includes 8-4A-3, access to and frontage on a roadway. Access shall be taken from the required frontage, unless the property also has frontage on an alley or an approved private road. The County Development Services staff appears to agree the required frontage for the property at 5900 East Zaffer Ridge is on Zaffer Ridge Street, and that the 10-foot wide access easement on the east side of the Painted Ridge subdivision does not meet the legal requirements to be an alley or an approved private road. The staff then claims the easternmost strip of the subdivision provides the owners of that property secondary access. I can find no reference to secondary access in the Ada County zoning ordinance. In addition, the owners of the property are using the strip as their primary access route to their property. The staff report goes on to convey that the county's mandatory legal requirement is subject to the whims of the homeowners association and the board. I disagree. Its board, the HOA board. Since when do HOA boards have greater authority than our duly elected Board of Ada County Commissioners? Zoning certificates. In the Ada County Zoning Ordinance 8-7-1, Part C, the zoning certificate shall be invalid upon violation of any regulations of this title on the subject property. Daily, on a daily basis, Title 8, the Ada County Zoning Ordinance, is being violated by the owners of 5900 East Zaffer Ridge Street when they access their property from anywhere other than the required frontage. Therefore, the staff's proposed findings are frankly nonsensical when they say the board finds that no specific action is required to satisfy this condition because it is required as a term of approval for the zoning certificates and the building permits. In 8-7A-8 of the County Zoning Ordinance, it states that the board may require conditions of approval that it deems necessary to protect the public health, safety, and welfare, and or to prevent undue adverse impacts on surrounding properties. In other words, there is a good reason for the county's conditions of approval. If not, or if the county does not intend to enforce them, why have them at all? In your last hearing a few minutes ago, you were talking about undue hardship. It does not appear that there is any undue hardship caused to the owners of 5900 East Zaffer Ridge Street to be required to use the actual paved ACHD public roads. It's not a longer trip. It goes literally directly right to the edge of their property. It's not further from their house. In fact, it might be slightly closer. The Local Land Use Planning Act in Idaho Code provides for development agreements. 67-6511A, development agreements reads, each governing board may, by ordinance adopted or amended in accordance with the notice and hearing provisions provided under section 67-6509 of Idaho Code, require or permit as a condition of rezoning that an owner or developer make a written commitment concerning the use or development of the subject parcel. It goes on to say, unless modified or terminated by the governing board after a public hearing, a commitment is binding on the owner of the parcel, each subsequent owner, and each other person acquiring an interest in the parcel. The agreements in place regarding the Painted Ridge subdivision are binding on all of us who own property within that subdivision in order to protect public health and safety and prevent undue adverse impacts on surrounding properties. We are here this evening to ask the county to please enforce those agreements made between the various owners of the property, their successors, and Ada County itself, and require the owners of 5900 East Zaffer Ridge Street to access their property from Zaffer Ridge Street, rather than along the entire east side of the Painted Ridge subdivision, which I calculated to be about 1,300 feet long of a 10-foot wide dirt strip.
So it looks like this road right here is the issue rather than, I guess, going through here. Looks like they blocked it or something. So they've been driving right by Sharon's house right there. All right, anyway, let's keep going.
James Madison said, in republics, the great danger is that the majority may not sufficiently respect the rights of the minority. I understand there are 17 of us homeowners along that east side of Painted Ridge. We are a minority of members of the Painted Ridge subdivision. We are about a tenth of the people who reside there. However, the adverse impacts on us from the behavior of one property owner are extensive. Although those of us adversely impacted by the ongoing traffic along the former access easement might be a minority, we should be able to have the expectation that our elected officials will respect our rights, including our private property rights. If the county does not intend to honor and enforce the agreements into which it enters, why have those agreements in the first place? Thank you, gentlemen.
Are there any questions? Any questions?
Well, I guess maybe for the sake of the lawyers, probably as a preliminary matter, bring up the fact that all three of us are very well acquainted with you, and so I'm wondering about, recusal or bias or anything like that. If what you feel on it, and we should probably have to make a statement.
I've known all of you for a very long time. I am not an attorney, so I don't know what is required of the board other than acknowledge that is the case.
I just want to take that issue off the table in case this does go to court. But I think for the record, I should say I'm very familiar with the appellant.
Well, Commissioner Davidson, what this board has done in the past is it's frequently we know a person testifying in front of us, and what we have done in the past is acknowledge the fact and then state that we can make an unbiased decision notwithstanding the fact that there's a person. That's what I think that's safe to say.
Well, I think I can state that for the record then.
All right.
And if needed, I'll say that for the record as well.
Okay. Well, we got that cleared up.
Okay, thank you.
Okay. Any other questions?
So how do you respond to the HOA who feels that
The HOA has stated that they prefer to have the traffic on the dirt path rather than on the 30-foot wide paved public street. There are some people who live along that street who don't want the added traffic from what is going on as development at 5900 East Zaffer Ridge. If it's too much traffic for a real road, it's definitely too much traffic for a 1,300-foot long, 10-foot wide dirt strip that starts less than 5 feet from my primary bedroom.
Yeah, right here.
did they have a board that voted on their position?
We have a board. The homeowners association meeting, I would say probably half or more of the people who were voting on anything were represented by proxy and didn't consider anything, but this issue was not brought to a vote of the entire homeowners association. I and some of my neighbors have been trying to work with the board, through the board, against the board, get help from the board to deal with this issue for several years now, and again, with absolutely no results. And so that's why I'm here today before the board with the real authority and asking again that you protect us even if we're a minority and others in the subdivision don't want the traffic on the actual real paved public road. But all of those agreements that were signed through the years, including by multiple former owners and the current owner agreed when he applied for the zoning certificates and building permits to comply with the Ada County Code. Do the words in that code, in the zoning ordinance, mean what they say? They don't say, maybe it's okay if you want to go somewhere else. It says you shall use that frontage. Shall is mandatory. It doesn't say you can use something else. To me, it's painfully clear.
Okay. Any other questions?
Not at the moment.
Okay.
Thank you.
Okay, thank you, Sharon, and you will be able to make a rebuttal if you choose.
Thank you.
Okay, I have a couple of people. I have down here Troy Ashworth as indicated an applicant. Are you a co-applicant or?
I'm right here.
So, Chairman, Commissioner, he is the applicant for the zoning certificates of
Oh,
appeal,
okay.
and so we've historically given the same amount of time
Sure.
as the
All right.
applicant to address
Go
the.
ahead. Sorry.
All right, my name's Troy Ashworth at 5666 East Felly Rim Court, Boise. So, let's see. We purchased this property a couple weeks ago. I was born and raised Southeast Boise. We live in Southeast Boise. We saw this ranch come on the market, just under 3 acres. Not a lot of land in Southeast Boise available. And so with this property, we bought it. We have kids that are 4, 7, and 9, and we're just looking to have a safe place for us to be able to have horses and enjoy the property. The quote-unquote development that's been occurring is just simply renovating the old ranch and improving the property. There's no actual development that's going on. So the property, that driveway's been there for 52 years. Sharon purchased her property in the community 2.5 years ago, knowing the existence of the driveway. When I was looking to purchase a property, I looked to make sure there were legal easements, and there's recorded legal easements for the driveway back in 2013. And that easement was not granted by the HOA. It was not granted by the developer. It was granted over 4 years ago. So in 2013, when Painted Ridge was first started, then they modified the easement. They clarified it. Again, it's a recorded easement, nice and clear. And in the plat, they have the easement for the first 500 feet or so of the driveway with ACHD approval and sign off. The second phase of Painted Ridge, they did another plat for another 750 feet or so. I do agree with Sharon that the driveway is probably 1,200, 1,300 feet, something like that. Now this driveway, it's kind of hard to see, but you can see where the driveway comes in. The outside of there being a written express easement, the purpose of it, the access is it's what leads to the front door. It's what Amazon uses, what UPS is going to use. The prior owner actually had to call emergency services and an ambulance had come in, and they came in that direction. So the driveway is the access to the front of the house. You can kind of see where the driveway comes up in the circular drive. It's the access to the shop. It's also over, I don't know if you can see it, there's a little white thing right there, down and over to your right. Yeah, oh no, no left. Yeah, right there is where the new hay barn is going. So it's also where we're going to be able to bring in the hay and deliver the hay into the hay barn. So everything we've done to the property, which has been removing over 120 yards worth of trash from the property. By tomorrow, we'll finish removing over 100 yards of wood chips that have been just thrown around the property. Plus, we burned a whole bunch of twigs. We've just been cleaning the property up. So it's been 2 months worth of traffic that has been a home remodel and cleaning up of a 52-year-old ranch home that had just been kind of let go. So most of the neighbors are pretty happy with us. We got rid of an old barn. We got a permit for it. We went through all of the right process. I'd like to say Leon and his staff have been amazing. I was shocked at how great they've been to work with. So we got the zoning certificates, we got the permits. All we're doing is building the horse run. It's a shelter for horses on one side. The other side is for hay storage, and then a barn for horses. It's pretty simple. And the barn is pretty much in the exact same location as the dilapidated, unsafe, falling down barn that was there before. Yeah, I don't have to let Wyatt have more time, but let's see. I wrote a whole long thing to say, but ultimately, I think the appeal is on the barns, but I don't really think the appeal has anything to do with the barns. I think the appeal is just that Sharon doesn't like the driveway that she bought her home right next to, very well knowing. The CCNRs also mentioned that driveway easement, that's how they refer to it, the access easement, it's right out there. And anyone buying a property or buying it subject to the CCNRs, it's written right into there that this is the access for this home. There is Zaffery Ridge going into the back of the property, but going into the back of the property really doesn't make realistic sense if an ambulance is coming and they're trying to wheel through horses and horse gates and horse manure and weeds, and they're gonna actually take the driveway right to the front door. So we're just looking to have the barn and be able to have somewhere safe for our horses, and all we're doing is making it a really nice property. So thank you for your time. I'll let
Maybe the board might
sorry,
like
questions?
maybe the board might like to ask you a question or two. Is there any questions for the applicant of the original application?
So I want to just clarify that there's no commercial aspect to this. You're not planning to run a business or a horse riding business or anything like that.
Nope, it's a 5-stall barn. We have 2 horses. So nope, the commercial activity is just contractors coming to do the remodel. We pretty much replaced everything in this little 1,500 square foot ranch home. So it's been pretty busy, but it's just normal home remodel. There's no commercial activity.
How much traffic are you expecting on a day-to-day basis down that road?
It's just a single family home. There'll be much less than there is now. I mean, all there is on there is a barn. It's just for horses and barn and a 3-bedroom home.
Okay. Any questions?
Just to amplify what Commissioner Davidson just said, or ask, so the traffic that's currently going down is for the construction, et cetera, the remodeling, all the cleanup of but after that is all done, it'll be a single-family home. It'll just be normal traffic for a single-family home.
Correct. Yep. That and anything accompanying the horses, but yep.
Okay, well, I have a question there. I see where the driveway is, back to where the circular driveway is.
Yep.
How do you access that point? Is there a road right there? I don't see a road there.
Are we talking up right by the house?
We're talking up in the northeast corner.
Yeah.
I can't see that angle.
Coming in right from the very top down.
Corner right there, yeah.
That's where the driveway comes in at.
But how do you access that driveway? Is there a road there, or how do you access it? That's my question.
Going to the north?
Other than the house.
It just comes in off of Columbia Road, and then the driveway runs down off of Columbia Road right into that driveway.
Oh, so the driveway is from Columbia Road, clear to the corner there.
Correct.
And is that just the applicant, Ms. Ullman said that's like a little 10-foot wide path. Is that what it is?
Give or take. Part of the agreement with the easement was that the developer would improve it when they did the subdivision. So the developer had it brought up to a basic road standard of just a dirt road, but that was done by the developer back in 2013.
Oh, I see. So it comes off Columbia Road and then it goes down, and that is the easement in question then, right?
Correct.
Not the driveway portion, but the easement from Columbia Road down to your driveway, right?
Correct.
Right. Now, is there any? Do you often or ever use Zaffer Ridge Street to access your property?
We can, and my wife will some, right over where you can see the arena and then the gray shed. So right there where the barn is, then yeah, she might be able to come and park off of Zaffery to go just directly to the barn. So there is access to be able to reach the barn, but never if we're going to the house or if we're going to the shop on the southeast corner. It would only be if we were only going to access the barn and that was it. Then it would be convenient.
And it's probably convenient if you're put hay or something in the barn, you might.
Except the hay storage is right here. So we'll come into here to unload the hay.
Okay. All right. Well, I don't have any more questions. Does the commission have a question? Okay.
And if I can, I'd like to have my attorney Wyatt.
Sure. Go ahead. You got a few more minutes, I guess.
All right, Johnson, 199 North Capitol Boulevard, Boise.
Is it Wyatt Johnson?
Wyatt Johnson.
Okay, thank you.
Thank you much. I wrote up a letter and I submitted it. It's part of the record here. And I was called because there might be problems with this one. So I went ahead and I did my own analysis of the code, and I looked at it and I wrote it up and I sent it in. And I did my analysis and sent in my letter at the same time the staff was doing their analysis, and they did their work. We didn't coordinate. We didn't talk. I didn't know where the staff was going to come. And when I read the staff report, I noted that we came to exactly the same conclusion. The way that I read the code is this issue of access. The code ensures minimum available access to any new developed properties, which exists. You don't want properties landlocked and you don't want them stuck with some sort of oddball access. It just happens that this property also has a driveway easement that's been there for 40 years. This driveway easement was there before any of the subdivision was there. The driveway easement was there for the first phase. The driveway was there for the second phase. And the driveway was there in the third phase, which is here. The driveway was there when Ms. Ullman bought her property. And you'll note this appeal has nothing to do with the subject matter of the application, the building permit. There's no problem with the structures. They're not violating setbacks. They're not raising any issues with the code. This appeal is about complaining about structures to try and get the county to take away a property right, which is an existing easement. I mean, it's an inappropriate use of the code. I think it's asking the county to stick its neck out and put itself out there and put itself at risk getting into a problem that it has no business being in for the benefit of a private party who would be basically not putting anything at risk. If she's got a problem with the easement, that's a private issue. It's not something to come and ask the county to torture its code in order to take away a property right. So I think staff's conclusion is absolutely right, and I think that you should follow staff's recommendation.
In your analysis of this issue, who granted the easement?
The easement was granted by this easement was initially granted by the underlying property owner before the properties were developed. And then it went through, and this easement was recognized in the first phase. It was recognized in the second phase. And then finally, when they did the third phase and added the street easement, that old easement used to be 30 feet wide. And when they granted the 30-foot street access, they narrowed it to 10 feet because they just needed to use it as a driveway to the extent they were going to continue to use it. But the issue is in the code, and where Ms. Ullman says there's no reference to secondary access in the code, there's not. Because to the extent the code talks about private roads and those regulations, it's got the qualifier, it only matters if there's not the regular required frontage access, which is after Ridge is. So it's got the frontage. So the code no longer cares about the size or length or anything else of that private easement. That just becomes a matter of the private public or the private concern. The code satisfied its concern, make sure that this property has sufficient access, which it does.
Okay, so if the original owner granted the easement, who would be the owner of the easement now?
The owner of the easement, the beneficial right of the easement, Mr. Ashworth owns the beneficial right of that easement. The easement overlays homeowner association common property. And in fact, the way that the covenants deal with that is the covenants go through and recognize that driveway easement, but they don't put any restrictions on it. The covenants recognize the driveway easement to say, we're not going to use homeowner funds to maintain it. They're going to leave that on Mr. Ashworth's to do. Is they carve it out, they recognize that it's there, but they also carve it out so that the owner association doesn't need to maintain it or do anything.
So that's the easement over all those properties along that line then?
Well, no, those properties, that easement's outside of those homeowners' property lines. Those homeowners' property lines go up and they end.
So who owns that dirt then?
The owners association has it as a common lot.
Oh, so it would be only the homeowner association could do anything with it because they own the property.
The homeowners association owns
This
it.
is that road right there.
So I mean, really, what we're talking about here is we're talking about Ms. Holmes trying to enforce essentially it's a nuisance claim from the use of a private easement. That's what she's really wanting to do, and if she wants to do that, this isn't the arena to do that.
Okay, any questions, Stu?
So, I mean, would you say that she's largely legally correct on her claims, but this is not the appropriate venue to adjudicate those because of what you previously stated?
Actually, I think she's dead on her. I think she's dead on her legal claims here. Anyways, which is why she's here. It's because she's trying to end run a case that she's not going to succeed with the court.
Is that because?
I'm sorry, I just didn't hear that you last.
This is Mr. Ashworth has legitimate easement right that is not across Ms. Ullman's property, and it existed before she was there. She came to it. She knew it was there. There's not going to be anything that she's probably likely to be able to do in court, but if she were able to, it would be to go to the courts. So she's coming to this body, asking this body to take away Mr. Ashworth's property right because she apparently can't do it any other way.
What about the previous development agreements that say that the road has to comply with Ada County Code?
They don't. The previous development agreements say that the developers shall all comply with Ada County Code, and they do not specify the driveway easement at all. If the prior development agreements would have asked for some condition, say the abandonment of that easement, they would have specified the abandonment of the easement. They make a general reference that is in all applications that says developer shall otherwise comply with Ada County Code, and there's nothing in Ada County Code that says that he has to abandon a private driveway easement if he's got, or that private driveway easement has to comply with any standards if the lot has full access. And the lot does have full access.
There's no standards it has to comply with as far as being paved or anything like that?
No, that only applies in the case where it's the exclusive access. In the exclusive access, the county's interested in making sure to protect minimal access to the lot so you're not getting landlocked parcels and things like that. If the property's got access, the county doesn't care about what the other private easements are.
And so what do you think a citizen's remedy to address this kind of situation would be?
Well, you should look at the title report when you buy the property. She bought this property next to an easement. She bought it, it was there. Conduct your due diligence. That's a citizen's remedy. You can't come into a property, know about an easement running next door, buy it, and then want the property owner next door to change their rights after the fact.
All right, thank you.
Okay, any other questions? Okay, thank you. Okay, we have Martin Sheffer. Did I pronounce that right?
Yeah, that was pretty compelling. I want to see what Sharon says as a rebuttal.
Yeah, into the it was signed by
In addition, the issue and took a picture just having an easement.
Okay, well, thank you. Thank you. Thank you. Okay, then Sharon, you have some rebuttal time. How much rebuttal time? Okay.
Thank you, Mr. Chairman. The prior owner, as you heard, had numerous illegal activities going on that property, which were causing even worse problems than just having an easement there, as Marty mentioned, all the large trucks. I believe it was Micron was out doing some surveying in the past week or so, and I used their point and took a picture with my ring camera, and I am holding a stake at the edge of the easement. You can see 10 feet is not very wide. In addition, the issues, so the Homeowners Association, again, has stated specifically they want the traffic on the easement. They don't want the traffic on Zaffer Ridge because there are children who play there. There are also children on the easement. Take a look at the first picture and take a look at the second picture. And when those two things happen at the same time, what happens to those darling children? When that truck comes around the corner and they're on their little tiny bicycles down on the ground, I don't want to see what happens in that situation. In addition, hearing that this is residential traffic, if you look at the additional pictures, you can see we had a dump truck with a dumpster on the back. It couldn't figure out how to get around the corner. So they backed the dumpster off and set it down beside our house, pulled up, eventually came back, collected the dumpster, all the while, beep, 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 beep.
Oh my God.
And it took, 10, 15 minutes for this process to take place. So the last couple of photos, the trucks with trailers, there was a dump truck back there, but you know what? Ada County's contractor collects the trash for this house from Zaffer Ridge Street because that's the actual frontage. We heard that an ambulance came down there, but ACHD required that property when that last split, that subdivision of that 10 acres, left the 2.77 acres and then that last phase 6 of Painted Ridge. That property was renumbered. It used to have a Columbia Road address. It's now 5900 East Zaffer Ridge. Paramedics are going to be terribly confused. They're going to come on Zaffer Ridge, I believe, to try to get to that house. If these folks build horse fences and don't allow people to get to their house from Zaffer Ridge, that's another disaster waiting to happen. So once again, I would ask this board to please enforce what it actually says in your law. The Ada County zoning ordinance is very specific, it's very clear. And you have the right to do that because multiple owners of this property, when it was larger and now when it's smaller, have signed that they agree to comply with the Ada County zoning ordinance. And that Ada County zoning ordinance says access shall be taken from the required frontage unless the property also has frontage on an alley or an approved private road, which it does not. Thank you.
Is there any questions? You want a question? Okay. Thank you.
Thank you.
Okay, there's no more testimony. We've had the rebuttals. You have some documents that you might need to submit for the record.
Yeah, Sharon, Commissioner, I know those are the record. They might already be in the original record, but we'll take them and confirm.
Well, you can check and see if they are. If they're not, we'll make sure that they are submitted. Do you need any other documents for the record?
Sorry about that, Commissioner.
Do we need any other documents to be added to the record before I close the public hearing?
Mr. Chairman, all records or all exhibits will be a part of the record that we're shown here tonight, and I believe we already do have these, but I will double check for you.
Okay, good enough.
And they're new exhibits to the records.
Oh, they're new. Okay. All right. All right. Then I will close the public hearing on application 2024-00619A. Public hearing being closed. It's the pleasure of the board. What say you? Any discussion?
I guess I can kick it off.
Okay.
I guess the issues raised regarding the
Remember,
easement
this is Tom Daly. Sharon Ullman ran against him.
and the validity of the easement and the use of the easement, I think are valid concerns, but I don't think they're in the purview of one of the appeal because we're appealing to certificates for building permits and not the easement. So that's not being appealed. First of all. Secondly, we don't have the authority to change the easement even if we wanted to. So I think we have to stay focused on the appeal itself, the issues themselves, which are the two zoning certificates. That is the issue in front of us, whether we grant the appeal regarding the certificates or not.
Okay, that's the way I read it as well. The appeal says right on here, the appeal of the director's approval of two zoning certificates. And
Go ahead.
Yeah, well, and what's come to light is there's a longstanding dispute on interpretation of our zoning code, and we have multiple interpretations of that. We have a couple of lawyers that came to the same conclusion apparently. That anyway, is there any other discussion on any other? Go ahead.
Well, I think from the evidence we've heard tonight, there's no question that the road is something of a nuisance to the neighborhood with the dust and the speed and sort of the safety issues. Overall health and safety to the neighborhood. I think that's pretty clear. But again, to me, the question is, can you use an appeal of the zoning certificates on this one particular project to sort of attack the legality of the previous, conditions of approval? And I don't know if I've seen that direct link. We've heard a lot of testimony that says you can't make that connection. I haven't seen any court decisions or anything like that that would allow us to use this particular process to address that particular issue, even though I would say it is a nuisance to the neighborhood. And it's from what we've heard, it's kind of in a bit of a limbo with who owns it and whether or not the owners can actually do anything about it. So I think if the HOA can find a way to resolve it, they'll be heroes to the neighborhood and heroes to us if we don't have to deal with it anymore. But legally, I'm not sure we can deny one person's zoning certificates to attack the problems with the easement.
Okay, just to amplify, yes, I agree. This is an issue for the courts or somebody else, not us. Even though the issues raised, as Commissioner Davidson said, are real and probably need to be addressed.
There's no doubt there's some real issues there, and they seem to be legal issues, but I don't see how they're legal issues relating to our zoning code and to the building permit. I mean, I'm still confused as to who actually owns the property, and therefore we understand that the applicant, not the applicant, the appellant applicant, but the actual applicant, it has the rights of beneficial use. But who actually owns it? I mean, what could actually be done by somebody? And we're not in a position to make those kind of decisions because that's not what's in front of us. So I
Let's say from listening to the testimony of the HOA president, it sounds like there's a possibility that the HOA may be able to resolve this. I didn't know if the HOA had completely absolved themselves of all responsibility for this or denied ownership or what, but having the HOA here to explain their position to me was helpful. And again, them saying that there may be some way to resolve this through the HOA, I think could possibly give the appellant some relief in the future.
Okay, having said all that, is there a motion?
I move to deny the appeal number 202400619-A, Sharon Ullman, appeal of two zoning certificates 202400323-ZCERT and 202400234-ZCERT.
Okay, is there a second to the motion?
Second.
Okay, you've heard the motion. Is there further discussion?
I'll just say again, we have had staff take more than one look at this. We've had legal go over it, and we're not coming into this without being briefed on the law here. We have taken a good look at it, and again, for me, I just couldn't see the connection between what the appellant is asking for in this particular process.
Yeah, I agree with that, and I think, like you suggested, they're with the head of the homeowner association agreeing that there could be a process forward. I would sure encourage the parties to do that.
And I would amplify that as well. I would seriously recommend that the parties get together and resolve this because there really are some issues here that need to be resolved.
Okay, having heard the motion, all in favor say aye.
Aye.
Motion carries. Thank you.
Okay, so the appeal, Sharon Ullman's appeal was denied. She will have to deal with this easement issue or nuisance in a different way, possibly with the HOA. Yeah, that's about it. I think in terms of the stories that I'm interested in looking at. All right, have a good one. Bye-bye.